We're turning now into one of our other specific as-applied topics, and this one is on scientific methodology and the admissibility of expert testimony. We have another wonderful panel in front of us with expertise and experience that can be detailed at the QR codes, as mentioned before. And to lead our panel is Judge Jennifer Choe-Groves, who is a judge on the United States Court of International Trade. Judge Choe-Groves received her AB from Princeton University, her JD from Rutgers, and her LLM from Columbia Law School. Prior to joining the bench in 2016, she was in private practice and also served as the Senior Director for Intellectual Property and Innovation and as Chair of the Special 301 Committee of the Office of the United States Trade Representative under both President Bush as well as President Obama. And so she has also done great service to the Law and Economics Center as a member of our advisory board for the Judicial Education Program. And she also did a great service to our students just about a year ago when she came and held a hearing here so that our students could actually observe. Invitation to all of you to do the same if anyone is so interested. The students certainly enjoyed learning from Judge Choe-Groves, and she was gracious enough to spend time with those students afterwards explaining what was happening in that case and what happens at the U.S. Court of International Trade as well. So always a pleasure to welcome Judge Jennifer Choe-Groves to lead our discussion.
Okay, great. Thank you so much, Donald, for the introduction and for inviting me here. Thank you. And I will say I had a great time. I did a court hearing here in this room, sat up here, the lawyers, we set up benches down there, and it was fantastic. It was a real case, and the students, I think, it was very well received. It was required, of course, for them to attend. The 1L class had to come, but I think they enjoyed it, and I certainly enjoyed it. So we're here to talk about 702. Again, I know we've had some introduction to the topic earlier and throughout the day, and so I think we can dive into more detail here. Our first speaker is Nathan Schachtman, who I think during the lunch was referred to as the expert in the topic. So we're happy to have him here. He's the owner of the Nathan A. Schachtman firm. He focuses on the defense of products liability cases. He's tried over 60 cases and 12 Daubert hearings. And so, Nathan, if you'd like to get us started.
Sure. I should say that I wear several hats in addition to having a solo practice. I'm of counsel to a firm in the Midwest, and I also sit on the board of directors of the Center for Truth and Science. The opinions I'm going to share with you are my own and not necessarily shared by these groups, but they should be. What I'd like to do is sort of go a little deeper and around what has been already said about 702. You hear a lot of glib statements that science and law are different, and I'm going to argue that there's been a major convergence between law and science, in part facilitated by Rule 702, but also procedural rules such as Rule 26 in federal court that require comprehensive reports from expert witnesses. It's helpful to remember that the federal rules of evidence are also, along with the LEC, going to be 50 years old in January, and that when they were passed, in 1975, they marked a dramatic shift from the common law. Rule 702 in particular is a dramatic departure from what was the law at the common law, where there were really just three things that an expert had to do. He had to have an opinion that was beyond the ken of the ordinary jury. He had to be qualified by education, training, or experience, and he had to have an opinion that was relevant to the litigation, and that was pretty much it. There was, to be sure, this thing called Fry against the United States, an opinion of the D.C. Circuit, a very short three-page opinion that articulated back in 1923 a twilight zone test for things that had been generally accepted. But it's interesting to know that that was not an epistemic test. It was a sociological test, basically nose counting. You go into an area of scientific dispute or controversy and you count noses, and at some magical point you get general acceptance, but it had nothing to do with the validity of the claims and the inferences involved. I would call it not a scientific test, but really just a survey. And that really changed with Rule 702, which, as you know, mentioned knowledge for the first time, that the opinion that was being shared with the jury or the fact finder had to have some basis in knowledge. It's interesting also to reflect on the Daubert case itself. In that case, it was a case against Merrill Richardson, the manufacturer of Bendectin, a anti-nausea drug that was very effective and is taken off the market in response to litigation, but went back on the market a few years ago under the name Diclegis. The defendant in that case tried to use Fry to do the work of an epistemic test. And it was a bit of a stretch. Some courts have allowed it. Other cases had allowed defendants to get away with it, but for the most part, Fry was rejected outside the narrow area of devices such as the polygraph. And the plaintiff argued in Daubert that there should be no standard, that as long as I have a qualified expert, he should be allowed to testify. Anything less than that is an infringement of my Seventh Amendment right. And that was the case that went up to the Supreme Court, which said you both lose. There is an epistemic standard, and it's not Fry. Fry would not have anything to do with knowledge, and Fry was not incorporated into the text of the rule, and you need to pay attention to the text. And the plaintiff lost because they said, well, there are substantive limits on what expert witnesses can say. And after 4 Supreme Court cases and a couple of substantive revisions of the Rule 702, we find ourselves where we are today. Just as an aside, there's a wonderful book by historian Jill Lepore on Wonder Woman, and you might wonder what Wonder Woman has to do with the Fry case, but the polygraph at issue in the Fry case was invented by William Marston, who was also the inventor of Wonder Woman and the lasso of truth. And his lasso of truth was more efficacious than his polygraph, and at least in his imagination. And it's really a really nice insight into what was behind or not behind the Fry case. But you saw that in 2023, there's been a non-substantive revision to the rule that was really just meant to tell judges we really mean it, and you got to stop, all these evasions and avoidances of gatekeeping. But what I would emphasize is that what they were asking judges to pay attention to were criteria of validity in the scientific evidence. Whether there was sufficient evidence, whether there was the quality of the evidence, whether the inferences were sound and valid, and whether the evidence was, the methodology was applied to the specifics of the case. And many courts had simply evaded doing that previously. I think that after Daubert itself was decided, the Federal Judicial Center recognized that we have a problem, that we have judges who are not trained in science, and we need to improve their game. And it was 1996, I believe, when the Federal Judicial Center published its first edition of the Reference Manual on Scientific Evidence. The third edition came out in 2011, and the fourth edition will come out really any week. I've been a peer reviewer of chapters in the reference manual. I think it's an important document. It's available for free online. The third edition was a joint effort of the Judicial Center as well as the National Academies of Science, Engineering, and Medicine. Although it's good, it has some mistakes, and I pointed that out in some of my writings. But nonetheless, it is a really good starting place, and judges have at least a source to go to that is non-partisan, non-adversarial, to at least get started in thinking about the issues before them. Not only has the law changed, with the advent of the federal rules and the evolution of Rule 702, but science has changed. And I think that courts and lawyers sometimes lose track of the evolution of scientific method. The statistical apparatus that is part and parcel of today's biomedical publishing, and I should say I try mostly health effects claims, did not start until 1920s when Sir Ronald Fisher wrote his first textbook on experimental method, and it began to develop the very notion of statistical testing and statistical significance. And that was carried forward by a brilliant Polish statistician, Jerzy Neyman, in the 1930s. The first randomized controlled trial, double-blind, wasn't published until 1948 by Sir Austin Bradford Hill on streptomycin and tuberculosis. There were no departments of epidemiology in American universities until the 1950s and the 1960s. When you go back and you look at epidemiology studies from the 1950s, they are primitive. Probably one of the most famous studies was the 1955 article by Sir Richard Dahl, a very famous epidemiologist, on the association between asbestosis and lung cancer. And it looked at only asbestos exposure and lung cancer. Now, this is the same Sir Richard Dahl who, along with Sir Austin Bradford Hill, is credited with the discovery of lung cancer being associated and caused by tobacco smoking. And when he was asked why he didn't look at tobacco smoking in the cohort of asbestos workers, he said, it didn't occur to me. He was looking at what we call a bivariate association between one exposure and one outcome. And that was pretty much how epidemiology was done in the 1950s and even into the 1960s. The idea of having a multiple variable analysis really did not come about until the 1970s or the 1980s. And the significance of that is that the studies that were done early were ones that could be done without having to worry about confounding. And confounding really didn't come into the analysis until much later. I should say that the statistical apparatus to study multivariable analyses was very cumbersome. I remember as an undergraduate carrying around computer punch cards, taking them to the mainframe to run a Fortran program, and that's what you had to do a multivariate analysis, because you couldn't do it. There were no computers to do it on other than a mainframe, and today you could do it on your cell phone. And so that's, some of the things that have changed. Another thing that's changed is this notion of a systematic review. So today, systematic reviews are sort of the coin of the realm in biomedical science. We expect authors to pre-state their clinical hypothesis, pre-state the kinds of evidence that they're going to consider and how they would weight each kind of evidence. They should have a statistical analysis plan, and then they should do a literature review, and they should be comprehensive. When I first started trying cases, systematic reviews did not exist. People did what are called narrative reviews, where they cherry-picked studies and they said, oh, here's a study, here's another study, they all support my opinion, and that was the end of the matter. And when you think about the demands of Federal Rule of Civil Procedure 26 and coming up with an opinion that specifies everything considered and all inputs into your analysis and your conclusion, it looks a lot more like a systematic review than the old-fashioned narrative review, which trades on cherry-picking and biased selection of studies to rely upon.
I'm gonna jump in here, just so we can give our other panelists a chance to also speak. But I think Nathan could clearly teach an entire semester on this topic, I'm sure. You have encyclopedic knowledge. Can we turn now to Tara? Tara is a trial attorney at Allen, and Allen. She focuses on personal injury on the plaintiff side. She formerly was a defense litigator, and she has tried cases involving multi-million-dollar cases.
I don't have as much to offer preliminarily as Nathan, but I have a little bit to throw in there. I think it's important to note that the standard in Daubert and the changes to the rule will likely have a direct impact on cases. When Daubert first came around, there was a study done where they looked at 3.5 million cases, and I think it was from 1990 to 2000. And in that study, they determined that civil defendants removed cases more often, significantly more often, when there were Frye standards in state courts versus having the Daubert standard in federal court. So there was a direct impact on how often defendants were actually removing cases when there was that higher standard in federal court versus some of those lower standards in some of the lower state courts. That same study also showed that after Daubert, initial filings by plaintiffs in state court went down significantly. So everyone sort of notices this and sees the higher standard. And then after 1993, defendants were moved much less frequently, which was, I think, really important to note. Let's see. I don't want to duplicate anything Nathan said, so give me just a moment. All right, I also think it's really important to make sure that your expert really understands in these cases what they have to talk about. I'm boots on the ground a lot, so I'm in court all the time. My experts often put together reports that just don't satisfy the requirements of Daubert. So if you're not reading your experts' reports and making sure they understand what's necessary, you're going to find yourself in a heap of trouble. It's not enough that your expert has the right conclusion. They have to have come to that right conclusion appropriately, accurately, and in accordance with the rules, and be able to communicate that to the judge. That often involves a lot of educating of the judge in those Daubert hearings. You have to explain to them things like, how different chemicals work or how different equipment works. And it's really important to go in there prepared yourself, but also to talk to your expert extensively, because what they have to show and the fact that they now have to be the proponent of this information rather than before where they were able to just put the evidence forward and then if it was opposed, be able to debate it. It's a little bit different. Now, they also have to be able to comply with the principles of the scientific method. I hope I'm not rambling here at all, but I've had cases where my experts want to talk about the standard nationwide. Well, I'm in a Virginia case and we're applying Virginia law, so you need to apply Virginia rules. I had a case where we had a student who was injured in a classroom explosion. The teacher was trying to show the polarity of chemicals, and instead of using beakers for that, they just took the jug, had it open on the table, lit a flame, and the whole jug exploded. A flamethrower was created and shot right at my student who was sitting right there. In that case, I talked to dozens of experts in trying to find the right expert, and they were all telling me things like, this isn't done, ethanol and methanol aren't used in classrooms, they've been abolished. Well, that's not the case in Virginia, so telling me that is completely unhelpful. Telling me what's typically done in California, what's done here, it's not helpful, and he just kept saying over and over. It's also important to explain to your expert what you're looking for, not to sway their opinion, but to make sure you're working together to get the information you need. In that same case, I had a lot of experts who were trying to blame the school. And they were right, the school was also at fault. But the teacher had the information himself to make the right decisions and did not. And in Virginia, I can't sue the school in this situation, so blaming the school repeatedly is unhelpful because the jury already doesn't want to blame a teacher. They already are looking for someone else to blame. And if you're pointing your finger as the expert at the school, even by mistake in your testimony, you're really going to screw things for me in the long run. So it's really helpful to be educated yourself and to make sure that your expert's not using just a results-driven approach, but using a really comprehensive approach that looks at the whole scientific method and how things are done in that industry standard. With damages, I know this can also be an issue. I have a lot of cases where So I do a lot of personal injury work. That's my primary focus. So I have a lot of injured clients who have medical bills the defense is trying to tear apart. My husband's a defense attorney. He does this all day, every day. It's not my favorite. I've had cases before where the defense tries to hire a bill coder or some kind of expert to go through my records and say why the bills are too high for this, the industry standard. And in a lot of those cases, if you ask them where they got the information, the defense expert is Googling it. And if you really try to poke holes in that, they might use an appropriate website from that Google search, and maybe their information's right, but if they can't tell you why that information is used standard and why that's an appropriate thing to rely on, well, then they can't testify about it. So saying I Googled it, that's not helpful. maybe the information in there is proprietary or something and they can't give you that information. Well, that's okay. They need to explain who relies on it. Do bill coders rely on that? Do hospitals rely on it? Who relies on it? Where did it come from? And why is it helpful? But I also find it, this is maybe not the time for this, but I think it's helpful when you're trying to rebut the defense's case to remember that rebuttal experts don't have that same standard necessarily as they do coming forward. So if you need to hire two experts so that one can sort of just poke holes in the defense's case and the other one can be the proponent of information, that's fine. You might not have the same person who can do both things satisfactorily in a case. I don't know how long that was, but I'll punt to
Okay,
Anne
that
Marie.
was short. That was only 5 minutes. Okay.
I speak fast, I apologize.
Okay, well, you can reserve your time for, for later. Okay, next we have Anne. She's a partner at Hollingsworth LLP. She's a trial lawyer focusing on the defense side of complex civil litigation. She's tried, for example, a patent infringement trial in district court in Delaware that resulted in over $2 billion in damages. So Anne, go ahead.
Oh, thank you so much. Yeah, so I've been practicing law for quite a while. Right now at Hollingsworth, my primary focus is product liability, personal injury, environmental toxic tort. And there are a lot of issues picking up from where Nathan left off, a lot of issues regarding good, sound, valid science and what can get into the courtroom and what should stay out of the courtroom. My partner, Eric Lasker, actually partnered with a professor here at George Mason, David Bernstein, to really set in motion the amendments to Rule 702, the 2023 amendments to Rule 702. And I'm very happy and thankful to be asked here today to talk about this because one of the key issues is really emphasizing what the rules changes did and what the courts and judges really need to focus on when you are evaluating whether an expert or expert testimony should ultimately get to the trier of fact. And so picking up on where Nathan was leaving off, the change in science. So science, the standards for science have changed tremendously over the past few decades, but I don't think that courts necessarily have kept up, and why would you? I mean, there are so many different types of law and cases and issues that you have to deal with, but a lot of my work recently has been in the ethylene oxide and PFAS arena where we're dealing with epidemiology and maybe a lack of epidemiology and how to assess that and analyze that, and we've seen the courts handle it very differently. So the purpose of the amendments to Rule 702 were threefold. One was to make it clear to judges that there are factual determinations that need to be made in the gatekeeping process before anything ever gets to the jury. And that can often be maybe a little counterintuitive for judges who think that, well, if there are factual issues about what science or what data or whether you're looking at the right studies or the wrong studies, whether you should be looking at animal tox or looking at epidemiology or what kind of epidemiology you should be looking at, those all seem to go to weight of the testimony, and those are factual issues for the jury to figure out, and you can vigorously cross-examine the experts to determine, are they looking at the right studies, are they using the right data and the right information? But the amendments to Rule 702 were specifically to re-emphasize what I think the proponents of the 2000 amendments thought they were doing, which is that there are factual determinations that have to be made by the judge in a gatekeeping role before you can determine whether the expert testimony is actually reliable to get to the jury. So you have to say, are they looking at the right data? Are they looking at the right facts? The second of the three big changes is making sure that judges understand that the preponderance of evidence standard, the more likely than not standard, is applicable to all three of those reliabilities, B, C, and D in Rule 702, right? So you want to make sure that it is more likely than not that the facts and data that are being relied on are reliable. It is more likely than not that the methodology is reliable. And then importantly, in subsection D, it is more likely than not that the expert has reliably applied the methodology to the facts in the case. And it's D that seems to be the big sticking point. How do you determine that? I can determine whether the methodology you used was a sound methodology. I can determine whether the facts and data that you used were sound. Even though I may not want to be the trier of fact in this instance, you have to be in the gatekeeping role. But how do I determine whether the methodology has been reliably applied to the facts in the cases. And that's where courts have the power to do an evidentiary hearing, a Daubert hearing, a Rule 702 hearing, as Tara was talking about, to really cross-examine or allow cross-examination of the experts. And we've even seen it in the AFFF cases in the MDL down in South Carolina, where the court set up a 702 hearing for the experts and prohibited the lawyers from asking questions. So the lawyers had to present their experts, and I think this might have been in the second or third round of the hearings, but the parties presented their experts, and then the court had questions for the experts, because the court wanted to understand what exactly are you relying on, what is the methodology you're using, and then do I understand that you have reasonably applied that methodology to the facts in the case? And so there's a lot of power that the courts have to do that initial vetting, and it should be done prior to ever getting to the jury, this testimony ever getting to the jury. And then third is really keeping an eye on sort of this last prong. Is the expert staying within the bounds of the methodology that they have said that they are employing? Because often a scientific expert or a damages expert can come up and say, well, I'm using this particular methodology, but then when you look at the opinion that's outputted, it has nothing to do with the methodology that was employed. And again, a Rule 702 or Daubert hearing can help a judge flush that out. And so, I think one of the things that we were talking about right before we started the session was in damages, and I think there are a couple of examples that I can give you in the damages world. Right now, I'm working on a natural resource defense litigation up in New Jersey, and we represent a company who has been sued by the state for ecological damages, restoration damages, and so they have a bevy of experts who are experts in biology, they're experts in geology, they're experts in statistical analysis, all the kinds of expert you would expect to find in an environmental case. But each of these experts is then also providing an opinion on what the dollar damage should be for the harm to the ecology, or the dollar amount should be for the natural restoration of the land. But none of them have accounting degrees or forensic science degrees or any sort of, any kind of economic degree in any way, shape, or form. And so they're not the right people to talk about this. But the state wanted to save money and didn't want to hire a damages expert. So a plan of attack, a reasonable plan of attack that any lawyer should implement, this shouldn't be any sort of privilege, is to really go after that portion of their testimony. Maybe they're an expert in biology, so they can talk about the ecology of the site, and we won't challenge that, maybe. But should they be talking about what the ultimate cost is to compensate for the ecological damage? No, we should have somebody who is a specialist in forensic accounting, somebody who's a specialist in natural resource damage assessment, who actually knows how to quantify the damage, and they just don't have somebody. So, that's a perfect sort of example of there are lots of different kinds of experts that you're going to see, and there are lots of different ways to attack them, or lots of different ways that parties will want to attack them, and it really is, instead of sort of throwing your hands up and saying, well, this all goes to credibility, this goes to the weight of their testimony, let's see if the jury buys that they're putting forward a good damages number. Well, in fact, it's up to the court to prevent any bad expert testimony from ever getting to the jury. Some of the other things that we see in the damages world, I do a lot with damages experts, particularly back in my patent days. When you're dealing with, and we were talking about this right before we said as well, how do you determine if you both sides have qualified forensic accountants or qualified, certified public accountants who are putting together a lost profits analysis, and they're both using numbers and data that come from the case, and they seem reasonable, and they're both using sort of a sound mathematical methodology, statistical methodology to get to, where they want to go. How do you determine whether both experts are, in fact, presenting a reliable opinion? Well, there's going to be dispute about what the lost profit window should be. There's going to be dispute about what the cost of reconstruction should be. There's going to be dispute about what the cost of replacement should be. There are going to be all of these data fact disputes, and the natural instinct, again, would be to say, well, let's throw that to the jury, the finder of fact, to determine which numbers are right, and then they will naturally pick whichever side and believe whichever expert is using those numbers. But that's just too much to ask for the jury, and quite frankly, under Rule 702, it's not the jury's job. It's the court's job to do that. And so, again, having a hearing, a 702 or Daubert hearing, to say, all right, what numbers did you use? Other side, why are you challenging those numbers? Why are those not reasonable? Why is your time window not reasonable? Why is your replacement cost not reasonable, et cetera? Then you, as the judge, can assess, did they use the right data? Did they use the right numbers? Did they use the right facts? And if not, then that is a basis to exclude that the expert testimony is not admissible. Or maybe they used the right facts, but they didn't use the right methodology. Or maybe they used the right facts and methodology, but under prong D, they didn't reliably apply the methodology to the facts. And so their opinion is sort of outside the bounds of what you would expect from the methodology they chose. So there are lots of ways that we want courts to really be the ones who are putting a hard look on whatever expert testimony is coming in the door before it gets to the jury, because we know once the expert is sort of stamped with that approval of being an expert by the judge, once they're qualified as an expert, which often happens before they enter the courtroom, we know the jury is going to listen to them and believe them, and it's really hard to, through cross-examination, to show a jury just how their opinion might be unreliable or unreliably applied. So that's sort of my background on why we were so fervent and why my partner Eric has been so fervent on getting this change done to Rule 702, and very happy to be talking to you guys about it.
I'm going to use one of my minutes if I can,
Sure.
real quick back. This is sort of implied by what Anne Marie was saying, but I do think it's important to point out that the rule is about admissibility, not credibility. So there might be all of the same information used, applicability was appropriate, the foundation for both opinions was sound, and the judge might let both in because it's not about who's right, it's about whether or not the information is admissible. So it's up to the fact finder at the end to determine who they believe more, but it's about admissibility, not credibility, which I think you inferred.
Yeah, very true.
Okay, great. Thank you all. So one of my questions is, we have an audience here of judges. What advice would you give to this audience about how to determine if a scientific methodology is sound?
The trillion-dollar question. I mean, there are people out there who suggest that judges lack the expertise. Professor Ed Cheng at Vanderbilt has written a couple of articles saying that we ought to do away with gatekeeping because neither juries nor courts have the expertise to resolve these kinds of issues. And if that's true, it proves way too much, because then that means juries are incompetent to decide the factual issues. And I can point to any number of really good examples of sound gatekeeping by judges. And I think the common thread is they held hearings, they listened to testimony, they listened to the challenge and cross-examination, they asked themselves, the experts, the hard questions. There was a decision recently from Chief Judge Rosensteigel of the Southern District of Illinois in the Paraquat litigation, where she was a very active examiner of the plaintiff's causation witness, and she came to realize that he was playing fast and loose with the inclusion criteria for a meta-analysis. And there's nothing really esoteric or beyond the ken of a judge to discern cherry-picking of evidence. So there are, I mean, you could put together a book, sort of the Berenstain Bears book of, bad expert witness testimony, and I think judges would get it, and I think they do when they take the time.
Yeah, one thing that that the advisory committee for the 2023 amendment has been continuing to do, and my firm's been active in continuing to do, is really a circuit-by-circuit analysis of what the bad case law has been in the past, pre-2023 amendment, and why it is overruled or no longer applicable under Rule 702, and we've provided this to George Mason, so it should be on the website for you to review. It's rather lengthy, over 100 pages, but it's a circuit-by-circuit analysis. And you really do see a very common thread. I think Nathan's absolutely right. If the judges don't just kick everything to this weight of the evidence and kick it to the jury, but really do have a hearing where they can thoroughly examine what the expert is relying on, what their methodology actually is, and how they're applying it, it really does become evident of what the expert's basis is and whether they're providing reliable science. I was in state court in Cook County, had 2 back-to-back trials, 2 different judges, same experts in both cases, and the first judge just absolutely no gatekeeping whatsoever, wanted to let everything go right to the jury. Of course, it's not a Daubert standard, it wasn't federal court, but we were still hoping. But the second judge, she was more reluctant to let this happen, and while she didn't exclude any expert testimony prior to trial, during trial, as the experts were testifying, we were making objections, and she was sustaining them. And there were several sidebars where there were 2 causation experts in particular that she almost pooled. And she did, in fact, come back and instruct the jury that one of the causation experts was actually not presenting a causation opinion. So that's, in our view, a little too late. We would have loved if that expert had never made it to the jury. We probably would have went on summary judgment, avoided a trial altogether. But it was helpful. We had a full defense verdict in the second case, and it really was helpful, I think, for in real time for her to be hearing this and realizing this and then making the appropriate rulings. Again, we would have loved it before it happened in front of a jury, but even in front of the jury, it really did help to say, no, what this guy is saying has nothing to do with causation, so you cannot think of his testimony as related to causation. So even in real time, I think there are ways that judges can sort of gatekeep and be helpful in trial.
I also think judges are not lazy. You're not afraid of hard work, any of you, so this is not something that you need to hear. But I think it's also important to understand that you might know nothing about what it is you have to decide. You might really have to dig in, do research, read the briefs, and understand what it is that you're learning about. Again, things like that methanol case I had. I've had cases where I don't know anything about electricity, but I've had clients who were involved in arc flashes and lost permanent hearing, and how that happened and why only one person in the room was injured when everyone was involved in the same explosion. That can be really complicated. So knowing that you might think you understand something, if someone's near a loud noise and they get hurt, that seems pretty straightforward, but there are a lot of complicating factors in things like electricity or in noises and loud sounds and how people's bodies respond. So you might have to go outside of what you expect to go outside looking at. And for me, I think it's really helpful to go through my report and make sure that you understand in English, not in complicated scientific terms, what it is that my expert's going to say, what he relied on, and how he came to his conclusion.
And part of that's on us, presenting really good experts who can clearly explain issues, which I try to do as much as possible. But yeah, I understand that's difficult, yeah.
So we have a lot of state court judges here, so can you tell us how this is playing out in the state courts? And we've heard some information today at lunch and earlier that some of the states have been adopting the 702 amendments, but what are you seeing in state court in real time? Is it all over the place?
Well,
It's all over the place.
it really
Yeah.
is. I mean, that's the whole point of a federal system. But there are some states where gatekeeping has evolved into a more serious concern. So in New Jersey, the New Jersey courts had articulated a pretty reasonable rule back in the 1980s and 90s, but it was just never applied. More recently, starting with a case called Kemp, a vaccine case, and then in re Accutane, the New Jersey Supreme Court said, well, we really mean it, and they affirmed exclusions of very well-known experts whose opinions just didn't add up. So, I mean, that's an example of a state that tends to be fairly liberal in the sense of allowing things in. I would call it libertine, not liberal. But, and then other states, New York still has a Frye standard, but they've distorted the Frye standard to be almost like a Daubert standard. So when they feel like it. So there's a case called Parker, which is a benzene leukemia case, where they really dug very deep into the methodology and affirmed the exclusion of expert witnesses. But then there are other cases in New York that go the other way, and I think it's because of a lack of a rule. New York is a case law jurisdiction. Those are the states where I'm most frequently practicing, but other state courts, like Illinois, again, a FRI jurisdiction that doesn't take gatekeeping very seriously.
Yeah, and what I found is it's really judge by judge. So in New York, I had a PFAS case up there. My particular case settled out, my client settled out, but the case is still ongoing against a couple of defendants. And an older judge who had refused to allow any expert depositions, because you're not even guaranteed depositions in New York, which is super fun, trial by ambush, and who wouldn't allow depositions and would not allow any FRI hearings or expert exclusion hearings, even though we begged and begged and begged for them. But he retired after my client settled out. And there's one defendant left, one stronghold left, and they have convinced the new judge, a younger judge, I think a judge who really understands the gatekeeping responsibility, who understands that bad science is bad science. He has ordered a hearing, an expert opinion hearing, an expert exclusion hearing, and the plaintiffs' counsel, who I've litigated against for many years, is going apoplectic, to the point where I just saw yesterday, or this morning, I guess, Monday, they filed a notice of appeal. They are appealing the judge's ordering of an expert exclusion hearing. So this is something that the plaintiffs' bar is really going to fight against. I thought it was an interesting statistic that Tara raised. Today, plaintiffs want to file in state court. They want to file in state court for this reason. They want to get their junk science in. It's really easy to convince a judge, hey, I have a qualified expert, let them say whatever they want. And then it's really easy to convince a jury, hey, look, my guy's qualified. Maybe I can even find somebody with a British accent to make him sound even better. No joke. And twice it's happened to me. And the juries are flattered, and they, oh yes, this guy must be an expert. And so we're finding, while the federal courts are getting better, although I have been in front of a few federal judges who I've wondered how much they've followed up on the rules and the amendments, the state court judges it's the Wild West, but the younger ones, I think, are starting to get it. At least that's been my perception, is that as they read up on the amendments and they sort of understand where everything is going, they're willing to entertain challenges and take them more seriously, take their gatekeeping responsibility more seriously. But the plaintiff's bar is going to be fighting this like tooth and nail, the whole.
I should say an Irish accent's even better.
I can answer this in a British accent if you all think I'm smarter if I do it. So in state court, I've seen that it varies exactly like they both have said, judge to judge. I can't really give any kind of consistency. I've seen these are personal injury cases with just medical experts that I'm referencing, but I've had cases where the defense has hired an ortho where I have a chiro expert, and I've been able to successfully leave out the orthopedic doctor because he doesn't understand chiropractic medicine. He didn't go to chiro school. That was a stretch. I was surprised I won it once. That's been shot down every other time. I've also had cases where I have a doctor who's a frequent flyer on the defense side. Again, my husband hires him all the time. And this doctor says everyone with soft tissue injuries gets better in 8 to 12 weeks, no question. Well, if you poke holes in that, this doctor had a car accident a long time ago, just like all my clients, had soft tissue injuries, nothing else, and he still has permanent issues from that. So I've had judges based on that exclude him, and I've had other judges say, that's a personal situation, we're not gonna involve that. So that face that you made is how I feel about it, and so, but case to case, it can vary in my experience.
Judge, somebody mentioned earlier the Zantac case where the federal judge had excluded the claims, and they're now up on appeal in front of the 11th Circuit, and the Delaware trial court judge denied the motion to exclude. That is also up in front of the Delaware Supreme Court. So I guess the salience of both rules are on the line.
So let me ask you a question. I had a trial recently, and we had 2 damages experts. One testified that the damages should be $70,000, and the other expert said it should be $300 million. Obviously same set of facts, but so what what do you do with that when it turns into a battle of the experts? And is your recommendation to hold an evidentiary, almost a mini trial ahead of time, and then you exclude one or the other, so it doesn't become a battle of the experts?
Go ahead, Nate. Oh,
I-
You go.
The basis for the opinions, so you're just giving us the conclusions, and the devil's going to be in the details. So it's going to be a much more granular opinion, how they got to the 30 million and whether each.
300 million
300 million, whether each.
versus 70,000.
You know, I think it was the Third Circuit years ago said that each step, each inference has to be justified. And I guess it's how they got there.
yeah, and it could be, at the end of the day, you're not excluding either expert, but there has to be, the judge has to be the first person who is assessing and getting into the analysis of whether all of those steps are, in 702, are met, and whether by a preponderance of the evidence you've found that the opinion is sound and admissible. And so it could be that both of them are looking at sound facts. Could be that they're using sound methodology. Could just be that they have a very different opinion on what the actual damages window is, or lost profits window is, or how long it would take. I'm not certain what your case is about, but I've got a damages case where there's a dispute as to how long a ammonia plant after an explosion should come back online, right? So you're going to have a difference in the window, which will impact your number. It could be that both of them are using reasonable facts, sound data, and a solid methodology, and you don't have to exclude either one. But it should be, the first step is to have you rule, as the judge, that yes, by a preponderance of the evidence, all of the requirements of 702 are met. And so this expert's testimony is reliable, and they might have a different conclusion, but they're both reliable. And then it really is up to the trier of fact, the jury, to say, all right, which number do I think is reasonable? But as long as the methodology is sound, and you have found that both methodologies are sound, the big problem with a big discrepancy like that is that somebody's doing something, right? And so you really, as Nathan said, you really have to dig down and figure out, how did you get to 300 million versus his 70,000? That's a huge gap. That doesn't make sense, and it won't make sense to a jury. So that's kind of a first, if it sounds like something fishy is going on, maybe something fishy is going on. Maybe not, though.
I've had judges also tell me that that's where the credibility versus admissibility comes in. It's just a matter of who you believe. If you can't win that argument, I think that's where, what I mentioned earlier on, sometimes you might need a rebuttal expert to come in and combat the defense's or the plaintiff's expert and say things, because that expert's not held to the same standard, because you're not putting evidence forward, you're just putting holes in the other person. So if you can't attack the methodology, I think you have to maybe come at it a different way.
Okay, thank you. So I'm going to invite anyone with questions to head over to the microphones. And while you're heading over, I'll just ask one question, which is, if you have a bench trial, are these same concerns still present, or is it lessened because you're not in front of a jury?
For me, they're still present. When the challenge happens, though, is an entirely different story. If the judge wants to wait and sort of do a voir dire of the experts, during the bench trial, because that's what fits with your schedule and it doesn't make sense to do an evidentiary hearing earlier, then that would be fine. It all ends up as part of the record for appeal anyway. So I would be less concerned about that myself. The real key is keeping bad science away from the jury.
There are two considerations. One is that since I mostly try health effects cases, and the key expert is going to be the causation expert, either the general or specific causation claims, if the 702 challenge is adjudicated before trial, there is no trial.
Yeah, that's true.
So we pre-termit the whole exercise, and we go home early, and everybody saves a lot of money. The other thing is that and Anne Marie is correct, that when I first started practicing, it was before 702 hearings. In New Jersey, you would ask for a Rule 8 hearing where you do a voir dire of the expert, and the jury would be excused, and you would do your cross-examination. And remember, on 702 challenges, the evidence you use doesn't itself have to be admissible under Rule 104, so it can't be in front of the jury. And sometimes the non-admissible evidence is fairly extensive, so doing it in the middle of trial can be very disruptive.
I think also there's a recent Fourth Circuit opinion that says that all of these decisions made by the judge have to be in writing or oral, and I think that makes me feel a little bit better in a bench trial because a decision still has to be explained to you one way or the other. So at least you know that you've been considered and that the judge has thought through everything.
Okay, Judge, you have a question?
Just generally, logistically, how should the hearing take place?
Ooh, that's a good question.
Should the judge be the lead, or should you have opposing counsel take the lead? Should it just be the one expert, or should you have the opposing expert there as well, so you can maybe have them battle it out in front of you?
I've seen judges go a million different ways on this. Some judges want to have all the experts in court hear from everybody, sometimes just the challenged expert. Some judges are relatively passive and let the parties make their case, and some judges are quite activist and get very involved in the examination of the witnesses. And there are no rules in federal court, or from my knowledge in state court as well, about how they run their courtroom.
Any other questions? No? There must be some questions. No?
We've answered them all.
Is there anything else you'd all like to say?
I'm exhausted. No, I think the only thing I was going to say earlier was that on this arc on the science side, that there's been quite a bit of navel-gazing about a replication crisis, and it plays into how the Daubert or 702 hearings are conducted. I think that the biomedical community is much less strident about its methodologies and has kind of looked carefully, and there's this whole emerging area of study called questionable research practices, where people have tried to get a better understanding of why there have been so many redactions, withdrawal of articles from the medical literature. In 2016, the American Statistical Association came out with a position paper on mostly on the misinterpretation of basic statistical tools, and it was somewhat pointed at courts, but also pointed at other experts.
I will say that I have had this bite me, excuse my language, in the ass the other way about how much you put in your expert designations and in the reports. I just talked about how important it is to be thorough, but I had a case where I took it over last minute. I tried it. Designations had been submitted. Reports were done by the time I got there. And apparently our medical doctor, who was a dentist, put in the report that he had expertise in how crashes occur and in force and all this other stuff. And so he said in passing something about the force of the crash, and then I steered him away, and the defense was able to really extensively question him about the force of the impact, which was not good for me because he talked about it so thoroughly in his report. So had someone looked at that report and said, well, that's not what we're qualifying him for, and he's probably not even qualified to talk about that, you want to make sure you read your report and that you know what's in there and that you're only trying to put forth opinions that are helpful, and the judge should try to acknowledge that.
Well, can you rehabilitate an expert if you withdraw his opinion on a particular area that's problematic, or has the damage already been done at that
I
point?
tried to do that.
Yeah, and the
Damage was
judge did
done,
not allow it?
And the judge did not allow it. Yeah.
That was going to be one of my questions, is how can you talk about carving out, if you have an expert who's talking about all kinds of things, including scientific methodology and then financial issues and, I don't know, corporate governance or whatever they're throwing, or a legal opinion. That happens a lot where I think experts tend to stray into giving legal opinions. How do you carve that out or rehabilitate, I guess? And do you have to withdraw sometimes on certain topics?
With that same doctor, I'll tell you, he was wild. If you want a fun story, he was pulling vertebrae out of his pockets at one point in the trial. This is real. It was crazy. And I tried to say repeatedly, at one point he said, "Let me digress." I said, "Let's not." That didn't work. I got the transcript. And it
Treated
just
as a hostile
went
witness.
on and on. So I started treating him that way. And eventually I just had to call it because clearly it was not going the way I was hoping it would. And I was just afraid the damage would be worse than anything else. And the judge, I think, had I asked for a moment, would have probably given it to me, but it would have looked worse in that context to take a break and talk to my expert who was clearly out of control. So I think sometimes you just have to call it.
I think that's right. I mean, I could probably talk for many days about corporate historian experts, but I know this is scientific methodology. But I don't understand corporate historical experts. If they didn't work for the company or they're not a fact witness for the company, I don't understand how
Or
they
an
could.
industry expert. I've seen that where an expert is called and then they start to go into, I've been in this industry for 40 years and let me tell you everything I know about the industry.
So, yes, and then I think, so an industry standard expert is one thing. I think the problem becomes that and I'm on the defense bar, so I'm going to blame the plaintiff's bar here. What plaintiffs really like to do with an industry standard expert is then have them review all of the historic documentation from the company and say whether that documentation evidences that they were or were not compliant with industry standards. Well, they're just reading words on a page. They're reading English. They are reading corporate documents that should be entered through corporate witnesses, fact witnesses. There should be authentication. There should be foundation, right? Explanation of what those documents are. But these experts are getting up on the stand and saying, well, I think what company X meant was, and that crosses a line, that should be inadmissible, unreliable. There's no methodology here. He read something on a page. Well, that's really the purview of the jury. And so I know that's not scientific methodology, but yeah, we could talk a long time about corporate industry standard experts or that bailiwick of experts. It's more and more judges are allowing them, thinking that plaintiffs need to put on their version of the corporate story, but that's really letting plaintiffs' counsel off the hook. Their version of the corporate story should come in through cross-examination of the fact witnesses, not through an expert playing a fact witness. But again, I could get on a high horse about that.
With the regulations too, I've had cases where the defense tries to put forth OSHA regulations and say, these are the regulations, this is industry standard. Well, sometimes those don't apply to the person that's being questioned or the person that's at issue. Sometimes those standards are inapplicable to the person who's not an employee or doesn't work there or had nothing to do with it. So just because something is a standard doesn't even mean that it applies to your specific case. So the applicability is really important.
Again, more to the admissibility than the weight, right? You need to make sure the regulations you're talking about, be it environmental regulations or workplace regulations, are actually applicable. So yeah, lots that judges can do on that front.
Okay, Justice McKenna has a question.
Yes, I was really interested in Tara Enix's, that case you talked about, the judge that would not allow you to withdraw that portion of the doctor's testimony regarding the force of the impact or whatever it was. I'm just wondering, was it because of Rule 104E?
It was a little bit about the fact that the judge told me in chambers that he was off the rails and there was no getting this doctor back, but he said that the reason he let it in was because we had introduced it in our case in chief, and in his report he extensively went into it, and so there was no reason why the defense couldn't ask him about it one way or the other. And he didn't even reference a rule or a reason why. He just said, not only did you talk about it on direct and open the door to it, which I then argued because I didn't really open the door. All he talked about was force of crash and a response. We didn't get into the nitty-gritty. I didn't ask him about his background. I got no information about, why he would be able to render such an opinion before the jury. But the judge said that his report went into it so extensively, and I wasn't involved in that, so I'm not going to take the heat for that, that there was no reason why it shouldn't be able to come in because the defense was able to prepare that way. And he talked about it himself, so it should come in.
Yeah, I was just wondering. I remember as a trial lawyer, I had a doctor that kind of went too far. But I was just wondering whether 104E, weight and credibility, this rule does not limit the right of a party to introduce before the jury evidence relevant to weight or credibility. And, when you have an expert that goes way beyond their expertise, then maybe it goes to their credibility.
Yeah. Thank you.
And have you seen judges carve out certain testimony?
I have not.
Yes.
Oh, you have? Okay.
Yeah.
Oh, I'm so
Oh,
sorry.
I'm sorry, okay.
I have a question about whether this goes to weight and credibility as opposed to the reliability and admissibility of an expert's testimony. In Washington DC, we had litigation in the trial court that's now been decided by the Court of Appeals after many years in our system of litigation against cell phone companies alleging that a specific type of cancer, I think it was glioblastoma or something like that, was caused by frequent use, let's call it that, of cell phones. And some of the experts were, first of all, litigation was being filed all across the country, and they seemed to be learning based on losses or not being able to move forward with the testimony being admissible in different states. They seem to be adjusting, not everyone, but some of the experts, their testimony and conducting additional experiments where the experts were quoting themselves to some extent, their own experiments. And so from your perspective, does that go to weight and credibility, the issues that I just sort of raised, quoting yourself, doing these additional experiments and so on, or does that, is there an overlap at all with the admissibility in terms of the reliability of the expert's testimony in terms of, that's the question, really.
It's a great question, and I'll just say that it could be both. An expert could say or do something that invokes a credibility, a personal credibility issue, in terms, let's say, the expert cherry-picks studies in an unprincipled way. But it also raises a validity issue of whether he's done a sound and complete analysis of the relevant data. So it could be both.
Okay. Well, I actually dealt with this litigation. One time there were 3 or 4 judges that dealt with it, and ultimately the Court of Appeals decided it. But it was very, very tricky with experts from all over the world, right? And obviously the financial benefit on the other side of, challenging the whole industry would have been enormous. So it was unnerving, to say the least.
Sure.
Are you seeing, since the amendments, that more experts are being excluded?
I think it's too soon to tell.
Okay.
I've only recently had the opportunity to brief expert exclusion under the amended rule this summer, and it was in an MDL in Ohio, and an MDL that had been going on for 13 years, and I think the judge just wanted to rule the way that he had been ruling, and found really interesting and creative ways to get around our arguments on 702 under the amendments. So that was disappointing because we thought we had a real shot to really get this particular judge to reevaluate how the standard had been applied pre-2023 amendment and really give this judge not an out, but sort of a, hey, look, there's an amendment, there's a different way to approach this. You should really look and consider and go back and look at your decisions and perhaps reconsider them, but that was not done.
There was a pattern that the advisory committee called attention to of judges citing cases decided sometimes even before the rule, before Rule 702, but certainly before Daubert was decided. And then ones that clearly were contradicted by the rule itself. And I would hope that judges will be more careful after it's been pointed out to them that the rule was amended specifically to shut down the practice of relying on circuit precedent that ignored the statute. That statute takes precedence over judicial decision.
I will say in defense of certain federal judges, let's say, that's what I can speak to. when there's an amendment such as this, where there's no mandatory training where they bring you all in and say, hey, guess what? There's an amendment to the rule. You should all know about this. That doesn't really happen. There might be an email that goes out from the AO, from the Administrative Office of the Courts, that attaches a PDF to an amendment, let's say. But we get dozens of those every week. So there's no real, I would say, focus on that. So I think it's up to the parties in their briefs to, and during oral argument, to educate the judges about these. And I guess that's all I'll say about
Yeah, no, I understand that
Yeah.
you don't need to
Yes.
be defensive. I think it is entirely an advocate's responsibility to put the right law in front of the judge.
And there are a lot of resources for advocates, and there are a lot of opportunities that we are taking. I know at my firm, every opportunity we get to talk to any counsel that's dealing with, which should be pretty much anybody, dealing with expert discovery and testimony and issues, really educating them on how to approach circuit by circuit, court by court, this issue to educate the judges. And even, I mean, we have a state court effort as well in conjunction with the work that Mr. Lasker has done with the advisory committee to really work on a state-by-state basis, even if you're not a Daubert state or you have a similar 702 rule, but to really educate that this is the proper way to assess scientific evidence getting in front of a jury.
And I think it is too early to tell, but I'm working on a brief for a case right now where I want to exclude the defense's expert. And it might be manipulative, but I'm making sure to reference in my brief, this is a new rule, and then explaining why the rule took effect so that the judge will maybe see there were issues and this is something I need to take seriously and I should address. Without saying to the judge, I don't think you know the new rule, but I want to make sure they're aware, because you guys have so much on your plate and so much changes day to day, that this is an issue and that needs to be paid attention to.
Yeah, I think that's important to do. And how would you handle that in state court if you're talking about a federal rule that's
Yeah.
changed?
We reference it and just allude to it. I'll say, typically we follow the federal court. This is what they're doing. This is an important change. Virginia has historically followed in trend with that, so this is how I think that we should proceed. And the judges have been very amenable to that. They're not looking to be appealed. They'd like to do what's going to go well for everybody. So I think if you educate them, everyone will win.
Any other questions from the audience? No? So Donald, are we okay with finishing a little bit early, or?
Sure.
Yeah? Okay.
Yes, let's give a round of applause.
Okay, thank you.